Hello, everyone, and welcome to the 8th session of Africa the Moot's Educational Series, an event organized by Africa the Moot, but sponsored by our dear partners at the Arbitration Channel. By way of a very brief introduction, my name is Stephen Fleischer. I am one of the founders of Africa the Moot, as well as one of the directors. And today we have a real treat for you, someone who truly needs no introduction, but who we will give an introduction to anyway in a few moments. Before we move on to our speaker, I want to briefly talk about Africa the Moot and also explain some of the housekeeping procedures of this call. So as a very brief introduction about Africa the Moot, as many of you know, we are a young organization, completely volunteer-based and completely not-for-profit, that is focused on increasing representation in the Vis Moot. The Vis Moot, despite being one of the largest moot competitions in the world, has had very low representation from sub-Saharan African universities. And that's something we're trying to change, along with the organizers of the Vis Moot, who have been nothing but supportive. Last year, a record was broken, and 12 sub-Saharan universities were able to attend the Vis Moot in person. And this year, we've continued to expand, having now 17 universities from sub-Saharan Africa under the Africa the Moot umbrella. As years have passed, so has Africa the Moot grown. We've recently started this series, an educational series, and have been delighted to see the willingness of practitioners and scholars to speak to our community. And in February, coming up in 2024, we are thrilled to announce that we will be hosting our pre-moot competition, once again, the East Africa pre-moot. This is the only in-person Vis pre-moot in sub-Saharan Africa. It hosts law firms from all over the continent of Africa, as well as law firms all over the world who fly in and host interactive workshops, guest lectures, and then ultimately a very exciting pre-moot competition that crowns one of the teams a victor in the end. Now, briefly on housekeeping before we introduce our speaker, this call will be roughly 45 minutes to an hour. We do not accept questions during the call, but at the very, very end of the talk, we will accept any questions anyone has. The video does not have the functionality for you to actually turn on your cameras. So if you do have a question, it's very simple. Just merely type it in the chat and we'll be able to take it at the very end of the call. So there's no need to wait. If you have a question during the call, just type it in and we will get to it at the very, very end. And all questions are obviously very, very much encouraged. So without further ado, I'd like to pass the call along to my dear colleague, Silke, who is a ex-Moody herself, a member of Africa the Moot's Media Committee, and also a coach of the Vis Moot team this year, who is going to give an introduction for a speaker who needs no introduction. So Silke, over to you.
Thank you very much. I have the immense pleasure today to introduce our guest speaker, who doesn't really need any introduction, as already stated. Professor Schwenzer is a Professor Emerita of Private Law at the University of Basel, Switzerland, and a former Dean of the Swiss International Law School. Furthermore, she's an adjunct professor at Bond University, Australia, and has been an adjunct professor at City University, Hong Kong, and Griffith University, Australia. Professor Schwenzer has a very, very long publication list, but most of you will be familiar with one of the leading CISG commentaries, the Schlechtrim-Schwenzer commentary on the Convention on the International Sale of Goods. From 2011 to 2018, Professor Schwenzer served as the chair of the CISG Advisory Council, contributing her extensive expertise. Beyond academia, she actively engages in legal practice, frequently serving as arbitrator, counsel, and legal expert in international disputes. We are very, very grateful to welcome her here today. Professor Schwenzer, the floor is yours.
Thank you very much, Silke, for this kind introduction. Ladies and gentlemen, welcome to our session on the merits of this year's Vis Moot problem. I'll talk about the second part of the second sub-issue of the merits problem. I gather Dr. Pereira, Cesar Pereira, has already introduced you to the problem regarding the merits, and so I'll take over from him and I will talk about duties to inform and Article 77 and Article 80 of the CISG. This is going to be my presentation. So we will start with duties to inform, and just to give you a very short overview, I'll talk about the possibility to develop duties to inform from the contract, then from the principle of good faith, then from general principles underlying the CISG, and maybe developing duties to inform from the otherwise applicable domestic law. So let's start with the contract. This is always when you're talking about the marriage, the first starting point is the contract. Remember, there are no, except for Article 12, there are no mandatory rules in the CISG. That means the CISG is always only supplementing the contract. The parties may derogate or vary from any of the provisions of the CISG according to Article 6. So the starting point is always what did the parties intend. And this is done to come to a conclusion. What the parties really intended is done by contract interpretation according to Article 8. So let's have a look at Article 8. So para 1 is the starting point. For the purposes of this convention, statements made by and other conduct of a party are to be interpreted according to his intent, where the other party knew or could not have been unaware where that intent was. So first of all, Article 8 is not only concerned with statements and conduct, as the wording seems to suggest, but it is indeed concerned with the interpretation of the contract itself. And if we look from a comparative point of view, if we look into civil law countries and into common law countries, then we find different starting points with regard to the interpretation of the contract. Civil law countries, civil law jurisdictions tend to look to the common intent of the parties. That means that is a rather subjective interpretation. Whereas common law countries have a rather objective interpretation, which can be found in Article 8, para 2. If the preceding paragraph is not applicable, statements made by and other conduct of a party are to be interpreted according to the understanding that a reasonable person of the same kind as the other party would have had in the same circumstances. Well, you might ask yourself, when does Article 8.1 apply and when does Article 8.2 apply? Well, in practice, if you have a dispute regarding the interpretation of the contract, you will not be able to find a common intent because party A says, oh, I meant X and I wanted X, whereas party B said, but I meant Y and I wanted Y. So there will hardly be ever a common intent that is discernible from the contract itself. Therefore, I would say in more than 95% of all cases where there is a dispute about contract interpretation, we have to turn to Article 8, para 2 and ask ourselves, what would a reasonable person in the shoes of the parties have understood by the terms of the contract? Well, and now we have something which those of you who come from common law countries, for those of you, this is not very well understandable. We have Article 8, Para 3 telling us in determining the intent of a party or the understanding a reasonable person would have had. That means both in Article 8.1 and Article 8.2, due consideration is to be given to all relevant circumstances of the case, including the negotiations, any practices which the parties have established between themselves, usages, and any subsequent conduct of the parties. So we have to look at all the circumstances prior to contract conclusion, but also to the conduct of the parties subsequent to contract conclusion. And we have especially to look for any practices and usages between the parties. And this indeed might become relevant in the case at hand. You might look whether there have been, or whether you might argue that there have been practices between the parties from which you may deduct such a duty of information in case of a cyber attack. If you look at Article 8, Para 3, you will find that what we know in common law countries, namely the parol evidence rule, is not applicable. That means even if you have a document, if you have a writing of the contract, then you do look outside of the contract itself, outside the four corners of the contract, in order to find out what the parties meant by the terms of the contract. So Article 8, Para 3 excludes the parol evidence rule that we find in common law countries, and I gather that many of you are coming from common law countries in Africa. However, this does not include that the parties themselves may add to their contract a so-called merger or entire agreement clause, because like any other provision of the CISG, Article 8, Para 3, that allows us to bring in all the circumstances surrounding the contract, can be excluded by the parties. And in the problem itself, the parties have indeed inserted such a merger or entire agreement clause into their contract. Now, the question arises, how do we interpret this merger or entire agreement clause? Does it indeed exclude any evidence outside of the contract, like is called for under the parol evidence rule, which is not applicable, I already said. So you might discuss this, and you can discuss it in favor of claimant. You can also discuss it in favor of respondent. You just have to find the relevant arguments for each side. You might be helped in doing this by the CISG Advisory Council opinion number 2, that indeed dealt with parol evidence rule and also dealt with merger clauses in contracts that are governed by the CISG. So this is contract interpretation. Do not forget that under the CISG, contract interpretation is not only done according to Article 8, but rather you also have to look at Article 9, namely international trade usages. According to Article 8.9, Para 1, the parties are bound by usages to which they have agreed, and practices which they have established between themselves. And furthermore, Article 9, Para 2, the parties are considered under otherwise agreed to have impliedly made applicable international trade usages. So you might even find an international trade usage calling for a duty to inform the other party if there has been such a cyber attack, which I think it will be difficult to find such an international usage, but you might give it a try. Okay, so just to summarize, you look primarily at the explicit terms of the contract, then you start contract interpretation according to Article 8, intent, reasonable person, circumstances, and here you have the problem of the merger entire agreement clause, and then you might finally turn to Article 9, international trade usages, and there are some scholars saying that the UNIDROIT principle may form an international trade usage. Thus, you might argue that you would like to rely on the UNIDROIT principles as an international trade usage. Please be aware, the UNIDROIT principles may come in two different roles. Namely, they are an international set, soft law, but in the problem you are facing in the Vis Moot, the UNIDROIT principles are also domestic law. They are the domestic contract law of all of the countries involved in this problem. So please distinguish neatly between UNIDROIT principles as international principles of commercial contracts and UNIDROIT principles as the domestic contract law of the countries involved. So, if you cannot find anything in the contract by interpretation, you might come to the next step to argue whether there was a duty to inform. And that might be, especially in civil law jurisdictions, that might be good faith. So let's have a look at the CISG. Good faith is mentioned in Article 7, Para 1. In the interpretation of this convention, regard is to be had to its international character and to the need to promote uniformity in its application and the observance of good faith in international trade. Well, if you look at the wording, Article 7, Para 1 only talks about the interpretation of this convention. It does not state that good faith is a standard for the parties' behavior. So if we again look at the starting point of common law and civil law, you will find that in civil law jurisdiction, good faith plays a very important role. There are even some countries like, for example, Brazil, where almost everything is based on boa fide, that means good faith. This is different in common law jurisdictions, especially England, but also Australia and New Zealand, where good faith does not play an important role or is not even recognized as being a standard for the parties' behavior. This may be traced back to different approaches between civil law and common law. Civil law is more concerned with fairness in the individual case, fairness in the outcome. Thus, the judge, the court, is much more intervening into the contract and might develop obligations from good faith. Common law approach is different. Common law emphasizes predictability. And as good faith is very vague, it's a very vague principle, it may jeopardize predictability. That is why common law does not favor notions of good faith. So, in Article 7, Para 1, we have good faith only mentioned for the interpretation of the convention. This is different in the UNIDROIT Principles. If you look at 1.7 UNIDROIT Principles, where it is stated each party must act in accordance with good faith and fair dealing in international trade. Thus, this is clearly the civil law approach to good faith, a standard for the parties' behavior. And this is even more important as under Article 1.7, Para 2, the parties may not exclude or limit this duty. That means good faith is mandatory under the UNIDROIT Principles, and likewise, as the UNIDROIT Principles are the contract law of all countries involved, it is also mandatory under the domestic contract laws. Well, at the Vienna Conference, the dispute broke out between civil law countries and common law countries, and it was not acceptable for the common law countries to have a general principle of good faith, and therefore we have only good faith in Article 7, Para 1. However, the background becomes evident once you look at practice. And if you take countries like Germany, but also Austria or Switzerland, where the good faith principle is a central principle of the respective civil codes, then you will find that in the interpretation of Article 7, Para 1 CISG, these countries tend to follow the so-called homeward trend. That means, for example, the Supreme Court of Germany regularly emphasizes the duty of good faith between the parties, just as if it were interpreting the German civil code. So if you need it in order to support your party's position, you might mention that it is controversial among the member states how to apply the principle of good faith under Article 7.1, and that there are important member states of the CISG with a long series of case law that are applying good faith with regard to the behavior of the parties, and then you might develop such a duty to inform under the good faith principle. Okay, let's now go on and ask ourselves, even if we were not allowed to develop a duty of information under good faith, might we then find other possibilities? And then we go to Article 7, Para 2 of the CISG. Let's have a look at it. Questions concerning matters governed by this convention, which are not expressly settled in it, are to be settled in conformity with the general principles on which it is based. That means the convention is based, or in the absence of such principles, in conformity with the law applicable by virtue of the rules of private international law. Thus, we first have to ask, is there a gap in the CISG regarding duties to inform? Under Article 7, Para 2, we have to distinguish between external gaps that are not matters governed by the convention, for example, like validity, but also, for example, you might have discussed this already, questions of agency, questions of limitation. All these are questions that are not governed by the convention, that are external gaps, for which we have to rely on the otherwise applicable domestic law. So Article 7, Para 2 only applies to so-called internal gaps, to matters that are in principle governed by the convention. And duties under the contract are such matters governed by the convention. Thus, this is clearly an internal gap of the CISG. So if you look again at Article 7, Para 2, to fill such internal gaps, we first have to ask, are there any general principles in the CISG from which we can develop such a duty? So you might scrutinize the whole CISG and look for examples of duties of information. You will find a lot of these duties of information. For example, Article 32, Para 3, or the general duty by the buyer to inform the seller of any non-conformity under Article 39. And then you will find quite a few duties of information, and you could try to develop general principles from these duties of information and rely on them and say, well, there is a general duty of information under the CISG. If that cannot be done, or if you are supporting the party, if you are representing the party that is against such a duty, then you might ask whether the UNIDROIT principles can be used as general principles of the CISG. There are scholars, again, that look upon the UNIDROIT principles very favorable. Again, this would be the UNIDROIT principles as an international soft law, not as the contract law of the countries here in question. And there are scholars supporting the view that the UNIDROIT principle can be regarded as general principles of the CISG. I myself, I'm very skeptical about that, but there you can find a lot of arguments in favor of this position. Finally, if there are no general principle that can be found under the CISG, then Article 7, Para 2 leads us to the otherwise applicable domestic law. You do then via the rules of private international law. And as I understand, all countries involved do have the UNIDROIT principles as their contract law that might be applied here. So once you have established such a duty to inform, then you might ask yourself, well, what are the remedies in case of a breach of such a duty? The remedies are laid down in Article 61 of the CISG if the buyer fails to perform any of his obligations. So this concludes the obligations that are laid down in the CISG, namely the obligation to pay the price and to take delivery. Those are the two main obligations of the buyer, you know that. But Article 61 covers all obligations, also additional obligations And if you have developed a duty to inform, this would be such an additional obligation, which is also covered by Article 61. So you have the possibility, the seller may exercise the rights provided in Articles 62 to 65 and claim damages as provided in Articles 74 to 77. So what can we find in Articles 62 to 65? This is Article 62. The seller may require the buyer to pay the price, take delivery, or perform his other obligations, unless the seller has resorted to a remedy which is inconsistent with this requirement. That is, the seller may require performance. Under the CISG, the starting point is the civil law starting point, namely that the aggrieved party primarily has a right to specific performance. That means payment of the purchase price. So you have a right to specific performance. The seller can alternatively also claim damages under Article 74. This is a provision that is common for buyers and for sellers in case of any breach of contract. The aggrieved party may require the payment of a sum equal to the loss, including loss of profit suffered by the other party as a consequence of the breach. There is a limit to this, namely, this is known from common law. Such damages may not exceed the loss which the party in breach foresaw or ought to have foreseen at the time of the conclusion of the contract in light of the facts and matters of which he then knew or ought to have known as a possible consequence of the breach of contract. This is different. The last point is different from common law. The rule under Hadley-Baxendale, our students from common law countries know this rule of Hadley-Baxendale. And there it is not a possible, it's not a possible consequence of the breach of contract, but a probable consequence of the breach of contract. So the question is, if the seller asks for specific performance, namely for the payment of the price, can we then apply Article 77 or Article 80? So the problem is the systematic order that we have in Chapter 5. Chapter 5 of Part 3 of the CISG contains provisions that are common to the obligations of the seller and the buyer. In Section 1, we have provisions regarding anticipatory breach and installment contract. This does not concern our problem. In Section 2, we have damages. We have Article 74, which is the basic provision for damages. And then we have Article 75 and 76, which do not play a role here in our case in the moot. However, then we have Article 77, which is referenced in the problem. And you see Article 77 is mentioned in Section 2 on damages. So this might indeed cause a problem. Does Article 77 also apply, or can it be applied by analogy, or does it form a general principle? Can it be applied to a case of specific performance, to a claim for the purchase price? Then we have section 3, interest. And in section 4, we have exemptions. Exemptions from liability. Those are Article 78 and Article 80. So we will now turn, after the systematic order, to Article 77, the mitigation of damages. Let's have a look at Article 7. A party who relies on a breach of contract must take such measures as are reasonable in the circumstances to mitigate the loss, including loss of profit resulting from the breach. If he fails to take such measures, the party in breach may claim a reduction in the damages in the amount by which the loss should have been mitigated. Thus, Article 77 has a duty to mitigate damages. The aggrieved party must take all reasonable measures to mitigate the loss it may sustain due to the breach of contract by the other parties. So examples would be the aggrieved party has to make a cover transaction. For example, the buyer, if the seller does not deliver the goods in time, the buyer must turn to the market and buy the goods from another supplier in order to keep its loss low. It may not await till the market rises, and the costs for a covered transaction would be higher. Examples, furthermore, include a preservation of the goods. For example, if the buyer wants to give the goods back to the seller after an avoidance of the contract, he has to preserve the goods so that they don't deteriorate or are not damaged. A party may have to take legal measures. For example, if state intervention is pending, a buyer may be obliged to remedy the defect if it is in a better position to remedy, for example, to repair a defect, then the buyer. A buyer may be obliged to discontinue use, for example, if a destruction of its plant is threatening, or even it has been held by at least 2 courts applying Article 77 of the CISG that the aggrieved party must negotiate with the contract breacher itself to come to new terms of the contract. So all these are reasonable measures that the aggrieved party must undertake in order to mitigate the loss after a breach of contract. So let's have a look. What are the consequences in case of breach of a duty to mitigate? If he fails to take such measures, the party in breach may claim a reduction in the damages in the amount by which the loss should have been mitigated. Thus, it has to be established how much would the loss have been if the aggrieved party had mitigated the loss by taking reasonable measures to mitigate it, and the damages are then reduced in the amount that could have been mitigated by reasonable measures. So the question you will have to discuss is this duty to mitigate not only applicable to damages, to a damages claim, but might it also be applied to a claim for specific performance? Might we even develop general principles from Article 77 under Article 7 para 2 and argue, well, Article 77 concerns damages only, but with regard to specific performance, there is an internal gap in the CISG, and Article 77 is an example for a general principle under Article 7, para 2 of the CISG. So this is open for your arguments. And now let's turn to exemptions. Remember, we distinguish damages and mitigation of loss, Article 74 and 77, and exemptions. We have two exemptions. One is Article 79 and the other one is Article 80. Let's have a look at Article 79. It reads, a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control, and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. So we have three prerequisites under Article 79. We have an impediment that was not foreseeable and that was unavoidable. The consequences of Article 79 are laid down in Article 79, para 5. Nothing in this article prevents either party from exercising any right other than to claim damages under this convention. That means if there is an impediment that is not foreseeable and not avoidable, then the consequences is that the party who failed to perform any of its obligations is released, is exempted from paying damages under the convention. It is discussed whether this also applies to specific performance. You may look this up especially in scholarly writing. To my knowledge, there has been no case that was decided under Article 79 regarding specific performance. So, and now let's have a look at Article 80. We get closer and closer to the problem. A party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. So let's briefly think about the relationship between Article 79. If you have a look at Article 79, it could well be applied to a case where the obligee, the creditor itself, contributed to the failure to perform, to the breach of the obligation. However, we do have Article 80, and that is more specific to and is only addressed to cases where the creditor caused the first the obligor's failure to perform, where the creditor contributed to the breach of contract or entirely caused the first party's breach of contract. So Article 80 is more specific than Article 79, and I would rather apply Article 80 to this case than Article 79. There's also a difference between Article 79 and Article 80 with regard to the consequences. If you again look at Article 79, it says, well, nothing in this article prevents either party from exercising any right other than to claim damages. Whereas Article 80 tells us a party may not rely on a failure of the other party. That means all remedies, not only damages, are excluded by Article 80. So Article 80 excludes any remedies for a breach of contract, whereas Article 79 in principle only excludes damages in case of a breach of contract. So what we are interested in is what happens if the parties have both contributed to the breach of contract. Let's again have a look at Article 80. It says a party may not rely on a failure of the other party to perform, which excludes the remedies, but then we have a clarification. To the extent that such failure was caused by the first party's act or omission. That means what is possible under Article 80, just like under Article 77, is an apportionment. This is at least possible in cases of damages. You ask, how much has the obligor contributed to the breach of contract, and how much has the obligee contributed to the breach of contract? And then you apportion the damages, for example, in the amount that the obligee has contributed to the breach of contract. And then the question arises, if we look at Article 80 this way, it's clear that an apportionment is possible in cases of damages. But it is disputed in scholarly writing whether such an apportionment, according to the relative shares of causation to the breach of contract, is also possible with regard to other remedies, whether it is possible with regard to avoidance, and what you are called upon to discuss, whether it is possible with regard to specific performance. Well, here you have specific performance in form of a money claim. Yeah, it is the purchase price. And money, a sum of money, can very well be apportioned also under Article 80. So you have to discuss this possibility under Article 77, under Article 80. You might discuss whether Article 77 in conjunction with Article 80 form a general principle under Article 7, para 2, or whether we can apply Article 77 or Article 80 directly to the case at hand, because the seller breached any duty of information that you have developed before. Well, that's about it. I think it's a very nice problem where you can discuss and show all your abilities. And with that, I thank you very much for your attention.
Professor Schwenzer, thank you so much for making this talk so specifically geared to the Vis Moot problem and touching on 2 articles in the CISG that our students are specifically agonizing over at this time with their respondent memos and as well with their oral arguments. I am going to briefly pass it to Silke, who will lead us on any questions if we have any. I'd like to remind the audience that Professor Schwenzer is happy to take a few more minutes to answer any questions if you have them. All you need to do is just type them into the chat. So Silke, I'll pass it over to you.
Wonderful. Thank you very much. Again, this is one of this is a 1 in a million possibility to ask Professor Schwenzer on these issues. So please, please do not be shy. Yes, let's start with the first question. So Eldon de Don asks, considering the development of a general duty under the CISG, which may be given rise to by specific duties under the Convention, what are pitfalls or indicators that may prevent such a development?
Well, always remember you have to argue for each side. Yes. And now you're arguing, you're representing respondent. That means you have to develop such general principles. Once you are arguing claimant, you have to take the counterpart, and you have to argue against such principles. Well, I think what are pitfalls against developing general principles under CISG regarding the duty to inform would be the argument that the CISG does not know a duty of good faith, and therefore that you cannot develop such additional duties from the CISG itself. So you have to argue any side, yeah. And with regard to Article 77, well, the pitfall is clear. The counter argument would be that Article 77 is only concerned with damages. It is not concerned with other remedies. Thus, it cannot be applied, and thus it cannot be a general principle under the CISG. I think it's easier with Article 80 to apply Article 80 indeed also to a case of specific performance, where specific performance consists in the payment of a sum of money. So I think you even do not need general principles to apply Article 80.
Thank you very much. Moving on to the next question. One of the principles underlying Article 77 CISG is the duty to cooperate. How expansive is this duty, and does it cover the information obligation?
Yeah, as I said, you might scrutinize the whole CISG with regard to duties of cooperation, duties of information, and from there you might argue and develop a general principle. Yeah, that is possible. And there will be the counter argument is that there is no duty to cooperate under the CISG because the CISG is not based on good faith, unlike the UNIDROIT principles.
Okay, any more questions?
So we'll give everyone a second to see if there are any lingering questions. But just before we do, Professor Schwenzer, I want to thank you once again. I just checked some statistics on this call. This is one of the most well-attended calls we've had in the Africa in the Moot series. It's also one of the calls that seem to get attendees not just from the region in sub-Saharan Africa, but all over the world. So thank you for being here with us. I have a feeling there were very few who were interested in seeing myself and Silke, and most of them were interested in seeing you. So thank you for being here. We do have one more question, so we'll let Silke pass along this question. I think we have time for maybe one more. If there's another one, and then we'll go ahead and conclude the call. So Silke, we can do 1, 2 more max.
Wonderful. So Anna is asking, what is the advantage of applying Article 77 CISG in the legal consequence?
Well, in the case at hand, I cannot see a big difference between the application by analogy or as a general principle of Article 77 or Article 80. Yeah, because both would lead to an apportioning, probably, because if a duty of information can be developed and this duty has been breached, it was probably not the sole cause for the problem with the payment of the purchase price to the wrong account. Yeah, it was probably both parties contributed to this problem, and then you would have to make, well, respondent might argue that it was the breach of the duty of information was the sole cause for the payment to the wrong account, but at least it should have a fallback position. If it was not the sole cause, then both parties contributed to the breach of or to this problem. That means the payment to the wrong account, and thus there should be an apportionment. So I think this apportionment can equally based on Article 77 and on Article 80. They have the same general principle underlying it. Yeah.
Thank you very much. I see one more question coming up. Christian is asking if Article 77 is applied successfully in regards to apportionment, would Article 80 apportionment still be relevant?
Well, I think Article 80 is the stronger point to argue apportionment. Article 77 is just, I would say, because it's of its systematic position. Yeah, Article 77 only relates to damages under Article 74, and it's difficult to apply Article 77 to a claim for a specific performance. I argue it in the commentary because I'm authoring Article 77 and Article 80. I'm arguing in the commentary that it should be also applied to cases of specific performance, but this is very much disputed by other scholars. So I think it's a safer way to rely on Article 80 and just to take Article 77 as a supplementary argument, more or less, just to exemplify a general principle that if both parties have contributed either to the breach or to the loss, be aware, yeah, this is very different, and you have to keep it apart. Article 80 concerns cases where both parties have contributed to the breach. Article 77 concerns the case where the obligor alone has caused the breach, but the obligee contributes to the extent of loss that has been caused by the breach. So those are two very different scenarios that you have to keep apart.
Thank you very much again. If there are no more questions appearing, I would say this concludes our session.
Thank you very much, and I wish all the students a great success, and I hope to see you all in Vienna. So have a good time.
Thanks again. We absolutely look forward to seeing you in Vienna. I think very, very many of the African Moot community is going to be there and will be representing the continent and the African Moot community in large well. So we'll see you there. And one last time, thank you so much for taking the time. This was a delightful lecture. So thank you so much.
Thank you.
Bye-bye, everyone.